Good day, students. Today we are going to talk about business law. Eh. As always, my name is Abna Kashikola, and you can call me on 081 3306443, or perhaps you can drop me an email at your tutorabna@gmail.com. The content of today, we are going to look at the law and the contract, the breach of contract, a remedy for breach of contract, termination of contract, the law of deficit, contract of sale, credit agreements, and so on and so forth. Defining law. Law is an objective set of rules that govern conduct. And of course, law regulates legal subjects, which are either natural persons, such as you and I, or juristic persons, such as companies, close corporations, etc. Legal objects are subjects over which legal subject are the bearers of subjective right held over legal subjects. And of course, subjective rights include the following. It includes the real right over the corporeal object, such as right of ownership and possession. Personal rights include right of certain performances, personality right to protect, right to claim performance. Personality rights protect one's personality rights, such as right to good name and dignity. So you also know that you have a right to the good name and also a right to the dignity. It's also important. We're also looking at the intellectual property. The right emanates from legal subjects, creative ability, and protect immaterial property such as copyright, trademark, and patent. We also have such things such as called a patent. Maybe you have a logo that you want to protect it not to be used by someone else, or perhaps you have a book that you've published, so you have to copyright it so that it cannot be made copy without your authority or without your consent. Capacity. Capacity is what one can do with one's right. It includes, if you have a capacity is what one can do with one's right. The capacity of people are different. Like a 21 years old person and a 17 years of age, they don't have the same capacity as far as the contract is concerned. Legal capacity to have right and obligation. If you have a legal capacity, means that you have a right. You have a right and obligation. Obligation is like you are obliged to do something. You have a legal capacity. So a legal capacity has to do with legal obligation. Are you able to enter the contract? Are you legal capacity? Are you legal capacity for that matter? Capacity to act. A capacity to act is the capacity to enter into contract, right? You see, you have a capacity to act in certain way of going to a contract. Capacity to litigate is the capacity to appear as a party in a court of law. The Latin term is locus standi in lucidio. So in Latin, they say it's a locus standi in lucidio. A capacity to litigate. Are you in a capacity to appear in a court or not yet? Those are the things that we must know, types of capacities that we are talking about. The law contract, definition of a contract. It's a valid agreement between two or more parties, natural or juristic. Remember, at the beginning of this topic, we spoke about a natural person and juristic person. A natural person is about you and me. And also, when I'm talking about juristic, we mean about companies. Those are the dualistic persons, which complies with certain requirements and which law recognize and attach rights and obligation. A contract itself is a valid agreement between two or more persons, be it a natural person or juristic person, by which requirement and which law recognize and attach rights and obligation. Talk about obligation. The obligation is a duty in the form of either giving, doing something, refraining from doing something, or tolerating certain situations. And it's integral in the establishment of a contract. So as you see here, an obligation within a contract can be something that you are entitled to do, or someone say you must not do A, B, C, or something that you must perform. Those are the obligation. What makes a contract valid? A contract is made into 5 categories: concessions, consensus, capacity, legality, possibility, and formality. Yeah? Those are the things that makes a contract valid instead of a contract to be. If one of these is not a part of a contract, that contract is void. That contract is not in force. We are talking about consensus. Is an agreement that is constituted by valid offer and a valid acceptance. So there must be an offer and acceptance in a consent. I'm talking about consensus between an offerer and an offeree. The offerer is a person who is offering, and now the offeree is a person who's accepting the contract. You know, there's a person giving the contract, which is the offerer, and the offeree is the person now in a position to accept the contract and to abide to the terms and conditions as stipulated in the contract. Terms in contract. There are some terms in contract. There is what you call essentialia or essential terms. These are the terms agreed between 2 parties entering into a contract. You know, let me say, when you are entering a contract to buy my house or to buy my car, we agreed on a price, and we agreed also on a deal. No, let me say on a let me say, if it's a house, we say that when buying a property, there's a right, or there's a transferring of now the property and the registration of the property. We have already agreed on the transferring date of the property, and also on the registration date of the property, and also to the purchase price. No, those are what we call essential terms, because the both party entering the contract has agreed upon the terms and conditions. And we have a naturalia terms, terms and condition enforced by operation of law. These are the neutral term that comes in already. Let me say, for example, if I'm buying, let me say I'm buying something from your shop or from you. So I have a right, also the law, the law or the operation of law or the law itself, it's already the nature that if this property is not in a good condition, I have a right to return back to you. Those are the things that comes in already. You know, these are natural part of the contract. But the defects of the property, I mean, I'm buying a car from the garage, but the defects of the car, I will return back the car. Without, in a contract, it's not that it's already an automatic part of the contract. Consensus continues again here. Condition in contract, we have suspensive conditions and also resolutive condition. What is suspensive condition in a contract? It suspends the operation of the contract, of the contractual obligation in terms of the contract until condition has been fulfilled. You know what I mean here? They are talking about suspensive condition. They suspend the operation of the contractual agreement in terms of the contract until the condition has been fulfilled. For example, let me say I have my son, and my son, I want him to go to Polytech or UNAM or in South Africa and a good university or anywhere to study. But I don't have enough and sufficient money to fund his studies. What I have to go, if I go to the bank, because now let me say I'm A and my son is B. Okay, let me say the bank is FNB. Let me say bank A is FNB, and I am Abna is B now, and my son is C. So the bank B, which is FNB, can only give me a loan if I sign a suretyship for my son C. So bank A, FNB, can only give a loan to Master Abna B if Master Abna B signed a suretyship for his son C. You know what I mean? So before I sign a suretyship, that is, I will be responsible to pay back the loan in case my son couldn't make it at school and work back to get the money. So the moment I sign, so this contract is now suspended until I sign a contract. You know what I mean? Resolutive condition render the continued, existence of the contract depend on the occurrence of the certain future event. This contract is already in existence, but at a certain point in future, it will cease or it will terminate. Let me say, example, I have to go abroad, and my friend, or I'm abroad, and my friend is renting my apartment or my house until I came back. You saw, this contract is in existence until I came back. After I came back, now the contract will terminate. That's because a resolutive condition in a contract. Factor that affecting consensus: we have mispresentation, we have mistake, juries of force, and undue influence. They are on page 30 to 31 on your textbook. Ladies and gentlemen, you can look at it, study on it, and you call me where you don't understand. Capacity to contract. As we spoke about capacity previously, that is let me say, is a capacity is something that you can do. Legal capacity, let me say. You have a capacity to enter into a contract now. The capacity is what do you have at that point of time? Are you qualified to do certain obligations? Like a minor older than 7 years but younger than 18 have limited contractual capacity. A person, a children who's 17 years of age and not yet 18, the child who is 7 years of age and not yet 18 years of age have a limited contractual capacity. So a contractual or legal capacity. So these people, they need a guardian or someone or a parent to enter into his into a contract. Let me say, for example, if you are applying to a certain university, they say now, if you are, for example, they say if you are younger than 21 or something, or 18, or here your parent or your guardian should sign the contract. That's why they are saying they are limited contractual capacity to enter the contract. So they need an assistant from a guardian or a parent. And of course, a person who is 16 can enter into can have a policy contract, but this contract should terminate when this person turns into 18. Should terminate when this person turns into 18, so that he can take now because at this point he was not the one who signed a contract, so he must now take a contract whereby him or herself is able to sign a contract when he's above age of 18. Legality, contract must be legally possible. Illegal or unlawful contract are those the conclusion, performance in terms of contract are forbidden by the common law or juristic law. We are talking about the legality, the contract, for the contract to be viable, to be valid, the legality must be possible. You cannot get into a contract to buy an ocean or to buy a sea. You cannot get in a contract to buy the birds and all the insects in the country. You cannot you cannot get in a contract to buy the moon. No, it's not legal. The legality, it must be, it's something that it's self-explanatory that is not possible to be done or to be exercised. The possibility here it also comes like performance in terms of possibility is also a part of the contract to be valid. Performance in terms of contract must be determined or ascertainable, and contract must be both subjectively and objectively possible. Example, a contract, let me say example, A contracts B to paint his house, but unbeknown to either of them that the house burned down the day before the agreement was reached. You know what? We just get into a contract. We get in a contract to, let me say you are getting a contract to, I get in a contract with you to repair my car. But by that time, my car is maybe with my brother, somewhere. He didn't tell me that the car is crashed beyond repair. So that contract is not valid. There's no possibility for you to repair my car if the car is not there. Because the car will reach in a contract without knowing that the car is no longer in existence. So this contract is not valid from the date of the agreement or from the date of the inception of the contract. Talking about formality here, formality. Contract to be in writing, there's not really a procedures that the contract, there's a formality of contract. It can be just even verbally, but there are some contract that must be in writing. We have some contract like a sale of immovable property. It must be in writing. When you are buying a house, my brother, or something, a building, an immovable property, something that you cannot be removed from on its premises, you need to have a contract, a written contract. You cannot just buy a house verbally that I'm buying your building. Yeah, tomorrow I'm buying your building and that's all. Buying it for 1 million, that's all. No, there must be a written document, what you call a contract. Suretyship. A suretyship, like for example, if you stand by someone to, let me say, if want to get a loan for my son who is not yet working, or for someone, a friend of mine, or for my mother, for someone who's not working, and I want to be there as a collateral in future if he fails to pay back. So the surety should be there in writing. Lending agreement and the National Credit Act, all those types of contract must be, the formal must be in written, because you cannot just have a credit act just in word. Just in verbally, you just say it, that whoever is going to borrow money, you must have at least a certain amount of incomes. Then it must be documented somewhere so that it will give clarity, and it's very important. Termination of contract, my brother. We have different types of termination of contract. We have payment. Most contract involve performance or obligation or payment method, Sometimes when I'm just in a contract with you to do something and to pay me, the moment you pay me, the contract ceased. Just for the payment of doing something. We have a release or a waiver. A release both parties, to release both parties from either from their respective obligation, whether fulfilled or not. We are just saying, for example, I owe you and you owe me, sir. When I owe you, you owe me 500 and I owe you 500. Sometimes I'll just forget about the money, just to release it and let it go. That's a termination of a contract. No, I'm no more owing you, or you don't no more, you no more owed me, so it's just a release. I just waiver of what you owe me, then from there we are done. Novation. Parties reach agreement in terms of which old obligation will be extinguished and new obligation will be created to take place. Let me say, for example, we had a contract, and when we looked at the contract, it looks like an old obligation. Now we came together to formulate some new obligations on that contract. That's what we call novation. And the old one, we relinquish it and we start over with a new obligation. That's what we call novation. Merge or confusion is a way in which a contract can terminate and occurs within a person's become both the creditor and the debtor in respect of some obligation. Let me say in a merge situation, let me say there's two, maybe let me say the two company A and company B and company C. Company A owe 5,000 to company B. So that's 5 company. So that, okay, let me take companies, ShopRite and Pick and Pay. Okay, ShopRite owe $500 to Pick and Pay, and Pick and Pay also owes $500 for ShopRite. Now what can do is that these two companies, they are all now they owe each other. Okay, now there comes Game. Now Game bought these two companies. This company, they were in liability of one another. Now Game took bought this company together. So now this company merged, they become Games. So now there will be no more liability on this company because they become one. They merged. So as we call the merger, they come together. The creditor and creditor become together. So this company now, ShopRite and Pick and Pay, they are bought by Game. So it's now one company. No one owns another one. So it's a merge. Set off occurs when contracting party owe reciprocal obligation toward each other, and they agree to simplify matter by revoking the two debts. Normally, these people is set off. When a set off is whereby the two of us owe each other, then of course we perhaps try to do some calculations and try to minimize the amount of that we owe each other. Then from there we pay according to what we have simplified the matter. Then now we're talking about insolvents. Insolvents, if I was in a contract with someone, then I become insolvent, is when my liability has exceeded my assets. So I have more liability than my asset, and I'm unable to pay anything that I owe from my people. So what is we do there's some legal process to before it, and you'll be declared as an insolvent. Then from there you will not be able to pay someone that you owe. Then the contract terminates without payment because you are insolvent. Contract of partnership. Contract of partnership. Partnership is a legal relationship. It's a legal relationship between rising from an agreement between two or more natural person, but not more than 20. So there's a mistake here. I say but more than 20, but not more than 20. In a partnership, start from 2 or more people, but should not exceed 20 people. Let me say, for example, we want to start up a company, me and my friends. So that partnership, if you are one, it's not a partnership. With whom did you partner now? It must be 2 or more, but should not exceed 20 people. So let me say, for example, if we are 20 or 21, and you can't say that you are 30 in a partnership. No, you are 20 in partnership. Maybe in a PTD, in a public company, you can be more than that. But in partnership, you cannot be 20, more than 20. You must be 20 or less. So if you want now to partner up with someone or with your friends, don't tell me that you are 21 to do a partnership. How many are in a partnership? No, we are 30. That's not a partnership. Legality, in a legal sense, in a legal terminology, a partnership is not more than 20 people. So make sure that tomorrow you're going to do a partner with your friend, you must not exceed 20 people. Partnership has no separate legal personality. Such cannot own property as all its property is owned by the partner jointly. Now, in a partnership now, like the property that you have that's operating is owned by jointly all of you. It's not solely for one person. That's why we are saying that they have a separate legal entity. They don't own a property. The property is owned by all the partners. And we are talking about the requirement for the validity partnership. We have consensus. We have valid offer and valid expectance without mistake, juries, and we spoke about already the validity. The validity of for the contract to be valid is the same as for the partnership to be valid. It must consist of consensus, valid offer and acceptance without mistake, juries, or under influence. No one should be due influence, no one should be jurors, and but there will be no mistake, and there must be an offer and acceptance. Contractual capacity, natural person, legal person can be partners. We're talking about a natural person is like you and I. And also dualistic people or legal person are dualistic persons like a company or some organization. Legality, the legality of partnership, we are talking about its membership. The partnership should not exceed 20 members. Possibility, there must be a possible way of being into a partnership. Don't just partnership for what? Partnership for what? If there must be something possible in a contract. Formality. We don't really have much formality, but it can be verbal or reduced in writing. But the formality should be there, verbal or reduced in writing. Those are types of requirement for the validity of the partnership so that it can be effective. Furthermore, we see you next time, ladies and gentlemen. You can call me on 08133064443, or you drop me an email at your tutorabner@gmail.com where you don't understand. Listen, this book, it's very well explained, like especially the business law. It's well explained, and I'm looking forward for you to call me, email me, ask me question to assist you. Thank you very much for your time, ladies and gentlemen. Bye.